Assalamu alaikum and welcome you all to this session of Practice to Pass F4 English Law. I hope all of you can hear me and there's no voice issue. Okay, so I'm your presenter for this session, Practice to Pass F4 English Law, and my name is Shazia Malik. I've been teaching this subject from last 13 years at SCANS Faisalabad, and I'm the subject teacher for F1 and SBL as well. From last 13 years, I've been teaching F4, and this would be the agenda for our next 5 days over here, Practice to Pass session. And our major focus would be on the practice of certain areas, and we'll be revising certain areas where I think the technical knowledge you should know, and all those technical knowledge which I think you should be clear with before entering into this subject. So this subject is not that much difficult subject. However, from knowledge aspects, there are so many things that you have not studied previously. So you should be okay with those areas before you sit in this paper. And you have to learn all those aspects. And inshallah, by the end of this session, 5-day session, you guys will be able to solve the paper and to solve the questions very, very promptly. I've divided the syllabus into 5 days, and by the end of day 5, we'll be done with the whole syllabus. And whichever book you're following, you need to follow a book for that, and all the handouts that are being provided to you through this session as well. Okay, so before starting the subject and the first chapter, I think it is important to have a look at the paper format, that how the exam would look like, and what the examiner expects out of you when you sit in this paper. This paper basically is divided into two areas, and the first area, as you all know, would be MCQs based. There would be multiple choice questions, and you'll be asked to opt one or two from those choices. And the second area is MTQ based, multiple task questions. These are scenario based questions, as you all know. Well, the first area would comprise 70% of your paper, and the second area comprise 30% of your paper. In the first area, you will be getting 25 questions worth 2 marks each, and you'll be getting 20 questions worth 1 mark each, making it 70% in total. And in the second area, we'll be seeing certain MTQs. MTQ is a scenario-based question. A scenario would be given and would be asked questions on the scenarios. Regarding the scenarios, there would be 3 questions worth 6 marks in total, and we'll be getting 5 MTQs from different areas of the syllabus. We'll be talking about MTQs at day 4 or day 5, and they would be 6 marks each, making it 30%. So this is how your paper would look, and basically multiple choice questions are going to be there, and you'll be given options, and you'll have to choose from the options even in the MTQ area as well. So this whole syllabus is divided into certain areas. We'll be studying English legal system in these 5 days. We'll be talking about certain laws like contract, like law of tort, like partnership, like company, and all those laws. So the assumption is that you have studied, you have gone through all these areas before. So that would be a quick revision from the technical aspects for all you guys. And then we will be attempting certain questions so that you are confident enough to handle this paper. So let's begin with the very first area. With the very first area, and that is English legal system. English legal system. So, as you all know, in F4 we study English law. So there are certain aspects of the English legal systems that you would be aware of. So let's begin. So it begins with the definition of law and certain different types of laws. We're going to begin with the definition of law and certain types of laws. Certain types of laws. So, law. If you're asked to define law, law is a formal mechanism of social control. As you can see over here, law is a formal mechanism of social control. What does that mean? That means that law is a collection of certain principles and regulations. Collection of certain principles and regulations which are established in a community, or established for a community, for a society, by some authority, by some authority. Now, this authority, or there has to be an authority, there has to be a regulator who would be setting the principles and regulations for that particular community. That regulator, that authority in UK, it could be the parliament, or it could even be the delegated legislation. Well, we'll talk about it in a while. Delegated legislation in the coming slides. We'll be talking about it. So there has to be an authority, and that authority sets principles and regulations for that particular community, which ultimately becomes the law for that community. You have to follow those laws, and otherwise you'll be suffering certain penalties. Certain remedies should be paid. You'll have to pay certain remedies for that. You will get a better understanding when we'll talk about different types of law. Okay, so let's begin with the very first category, and the very first type of law is common law. Common law. Common law was one of the initial legal systems that were developed in England, in English legal system, and it was basically developed by amalgamating, by mixing law of the land. It was basically developed by amalgamating or merging or mixing law of the land with what? Merging with what? Well, into the custom, the customary procedures that are being followed over there. Local customary law. Local customary law. So initially, when common law was developed, it was developed by merging law of the land with the local custom, and certain offences were decided, and regarding that offences, penalties or compensations were decided, and under common law, the compensation would only and only be in the monetary form. There was just one compensation that was paid, and that was just the money in the monetary form. And it happened after the Norman conquest, as you all know. When the Norman invasion occurred, they brought a certain law. They said that we have this law for this land, but they made it a point that they mixed it up with the local custom. And then common law was developed. Certain penalties were decided, which used to be monetary all the time. And this basically, everybody knew that what would be the compensation of which offense, which basically made this system a little rigid and inflexible. So this was the very first source for English legal system, and that was common law. Common law, which is basically derived from the customs from that area. And people saw that it is rigid, it is inflexible, and when the people were not satisfied with the decisions made under the common law, well, they made it a point that they filed certain petitions, and they said that we are not satisfied with the decision made under the common law. Well, that led to the formation of the next category, next type of law, and it was equity. For that sake, the other law was developed, and it was equity law. It was equity law. So, to deal with all these problems of common law, equity law was developed. And under equity law, well, equitable remedies were decided. Equitable remedies were decided in case of breach, and this was based on fair treatment. Equitable remedies were basically based on fair treatment. So when the equitable remedies were decided and that they were based on fair treatment, so that basically removed the problem of common law being rigid and inflexible. Well, it brought some kind of flexibility into the system, as it gives certain discretion, certain discretionary remedies were allowed. Judges were allowed to give certain discretionary remedies as they seem suitable for this situation. For example, where people think, or the one who brought up the petition, they think that monetary remedy is not sufficient. Money, where they think that money is not sufficient, there should be some other punishment. So they tend to go for equitable remedy. For example, specific performance. For example, injunction. Well, we'll talk about these remedies in detail when we'll reach the area of breach of contract. So this was basically the development from common law to equity. The problem of common law being rigid, the problem of common law being inflexible were basically all solved when equitable remedies came up. So one of the major development that occurred was the between common law and equity, and there are other certain types as well. Moving on, let's talk about another category, another type of law, and that type of law is known as public law. Public law. Now, what exactly is public law? Well, public law was basically a law that was developed by the state, by the parliament, by the statute, and it was developed for everybody, everybody living in a country, living in a community. So it was for everybody living in a country or living in the community. And these types of law basically identified certain behaviors which were considered acceptable, and likewise certain behaviors which were considered unacceptable. So the state said, well, this is the behavior that we are going to accept. This is the behavior that we are not going to accept. You'll be penalized for that. You'll have to pay remedies for that. So certain behaviors of the citizens of the citizens within the state were identified, and they were categorized as acceptable, as not acceptable. One of the biggest example, or you can say the category, one of the biggest example or the category for public law is criminal law, which we are going to have a look in a while as criminal law, because it is highly emphasized in this syllabus. So that is one of the example for public law. We'll be having a look at it in detail in a while. Criminal law. So what is public law? Well, public law is a law that has been defined for everybody living in a community, and certain type of behavior that is accepted, that is identified either acceptable or unacceptable. And for the behavior which is not acceptable, of course, you'll be penalized for that, and you will be suffering damages for that. You'll be paying remedies for that. So for public law, we'll have a look at it in detail in criminal law in a while. The next category, as opposed to public law, there was an other category, and that was private law. Private law. Well, where public law was for everybody living in a country, the private law, it deals with relationships between private individuals. Private law basically deals with the relationships between private individuals. It could be two individuals, private individuals, it could be two groups, it could be certain organizations or companies. So it basically comes up when there's a dealing between two private individuals, two private groups, a person or a company. Company, as you all know, is an artificial individual. So what role does the state provides? The state basically just provides the legal framework. State just provides the legal framework and asks you that, well, you can use this legal framework in dealing with other individuals. So private law basically deals with that, how individuals behave with each other, and is it according to what they have decided? Is it according to what they have decided before? Say, for example, in a contract, so is their behavior according to the contract or no? And of course, if it is not going to be according to the contract, the innocent party has a right to claim breach. breach of contract, the remedies under breach of contract. One of the biggest example, one of the main example under of private law, example or category you can say is the civil law system, civil law. And we'll be having a look at it in a detail in a while, civil law. Because these both these areas, criminal law and civil law, these are examinable areas, and examiner basically focuses on these areas. So when we'll discuss the examples, you'll have a better understanding of what public law or private law is. So next category, as you can see, private law and public law. The information is available on these slides as well. The informations are basically all the knowledge is being discussed over here in front of you as well. So moving on to the categories of public law, which is criminal law, and private law, which is civil law. So let's have a look at them individually, that what exactly criminal law is, what exactly civil law is, before we jump on to certain questions, before we see that how the examiner would test us on these areas. So next category, next type of law is criminal law. Criminal law. What is a crime? Basically, crime is an act prohibited by law. Prohibited by law. Prohibited, law has not allowed you to do that act. It is prohibited by law. You cannot perform that act. If you're going to perform that act, you'll be penalized under criminal law. You'll have to pay the remedies under the law. So for that sake, criminal law was enacted, was enforced. So if we talk about the purpose of criminal law, what's the purpose of criminal law? Well, the purpose of the criminal law is basically enforcement of certain behaviors. Enforcement of certain behavior. Behavior which are acceptable when they want to enforce those behaviors in a community by the citizens, and what they want is, what they want them to do is, well, to comply. Basically, they want them to comply. So the purpose of criminal law would be compliance to the legal system, compliance to the behaviors that the state want you to show. Okay, so how do we mention the case for this particular? Whenever the case comes under the criminal law into the and goes to the criminal code, how the name of the case is put forward? Well, the name of the case, the prosecutor's name is written first. It could be, you can write state or you can write R versus the name of the person who is the alleged criminal, for whom the state thinks that he or she is a criminal. So that person's name is written over here. R is the Latin word retina for queen. You can use it at the uh, uh, alternative to state. So R versus the person, the criminal, which the state thinks is a criminal, and this is how the name of the case is written, which is different. How do you write in a civil law, which we'll see in a while. Burden of proof. So burden of proof. Burden of proof is on the prosecution, is on the party which brought up the case, the party which brings the case to the law, and it is in this case always the state. It is in this case always and always the state. The burden of proof is on the prosecution, on the party which brings up the law, and it is in this case state. Standard of proof. Standard of proof. Like, what do we have to prove? Well, the prosecution has to prove that the person is guilty beyond any reasonable doubt. Beyond any reasonable doubt, the person has performed the act. Which was prohibited by the law, which is a crime. So that is why we are saying that is a criminal, and we are saying that beyond reasonable doubt. And if the judge is convinced, the judge is going to give the decision against this person. So standard of proof, like how much proof is required. Standard of proof means how much proof is required. How much? Well, it should be beyond any reasonable doubt. So for that, after doing that, the objective of criminal law is achieved. What is the objective? Objective is to regulate the society. To regulate the society. Regulate the society by emphasizing on certain behavior, that you should be behaving like this, you should be behaving like this, or you should not be behaving like this. So the society is regulated, of course, by fear of punishment. Of course, by fear of punishment, as it is the formal mechanism of social control. As it is the formal mechanism of social control. So, when the person is found guilty, what is the remedy that the person should pay? If the person is found guilty, what is the remedy the person should pay? Well, the remedy under criminal law would be a fine, plus it could be imposition of certain period of imprisonment as well. It could be imposition of certain period of imprisonment as well. So the fine and imprisonment, imposed imprisonment, could be the remedy for criminal law. As opposed to civil law, all these things would be different when we are going to talk about civil law, which is a category of private law between individuals, which is decided between individuals, involves the relationship between individual citizens. As we saw earlier as well, involves the relationships between individual citizens, not the whole citizen. It is between individual citizens. Individual citizen. So whenever there are two people, three people, and they are in dealing with each other, so what is the purpose of civil law? Whenever they're in dealing with each other and they come up to, there are certain disputes. So the civil law would help to settle those disputes. Settle those disputes which are between these individual citizens. Settle those disputes which are between these individual citizens. This is the purpose of civil law. And whenever the case comes up, how do we write it? How do we mention the case? Well, of course, the person who brings up the case is known as claimant. The name is written first, the party who brings up the case, versus the person who has to defend him or herself, the defendant. The defendant. And burden of proof is always on the claimant. On claimant, again, the party who brings up the case to the court. But when we talk about standard of proof, the standard of proof, like how much proof is required, but it is a lower standard, a little lower standard of proof, as compared to the criminal law. And the standard should be based on just the balance of probabilities. There should be enough probability, enough odds to tell that this person is guilty, defendant is guilty. You just have to show that other person is liable for his action. And if the court is convinced, the court is going to give the judgment. So what is the objective? The objective of this law is just to settle the disputes between the individual, of course, on the based on the framework that is provided by the state. And if the person is found guilty, what is the remedy? What is the remedy that you can get under civil law? Well, civil courts are going to decide on the remedies, and normally these remedies are, they order compensation, monetary compensation, but at times they can order equitable remedies as well. We just study equity. Equitable remedies like specific performance or injunction as well. Injunction, we'll talk about these in the area of remedies. So, well, that's a little introduction about the law and the certain types of laws. The examiner will be asking questions on this, and let's have a look at some questions now. As I told you, the paper would be based 70% on MCQs, 2-marker or 1-marker, and then 30% on MTQ. Let's have a look at some questions. Let's see if you're able to give me the answer. Okay. First question. Well, in relation to the English legal system, where did the common law originate from? Where did the common law originate from? Number 1, Acts of Parliament. A, Acts of Parliament. B, delegated legislation. C, custom. Well, the answer is custom. As we all know, common law was basically derived by merging law of the land with the customary practices. The answer is C. Another question. Which of the following is the name used for person who commences a civil action? Who starts a civil action, who brings up a civil action to the civil court? Appellant, plaintiff, claimant. Well, for civil action, the name to the party given is claimant. So the examiner will be focusing on such areas by asking you such questions. Let's have a look at some other questions. What does the term private law refers to? The body of laws that derive from deciding of cases. the body of laws that seeks to regulate the relationship between individuals, the legal system that states that person has the right of privacy, the body of law that seeks to regulate the relationship between the state and the citizens. Well, the answer is B. The body of law that seeks to regulate the relationship between individuals. Private law is between individuals. Which of the following is regarded as private law? Criminal law? Is criminal law a category of private law? No. Civil law is a category of private law. So one is wrong. Two, contract law? Yes, contract law is one of the form of civil law. So the answer is B. Two only. The answer is B. Two only. So this is how your examiner would be testing you. Examiner would test you on these areas, and civil and criminal law is the area where the examiner has most emphasized on. Okay, moving on. Then another distinction made in civil and criminal law is through courts. Well, there are different codes for civil law in English legal system, and there are different codes for criminal law in English legal system. When there's a case regarding civil, there are civil proceedings, you need to go to the civil code. Whenever there's a case regarding any criminal act, you need to go to the criminal codes. So let's have a look at certain civil and criminal codes in the English legal system, under the English legal system. So you can see the hierarchy of codes in front of you. Well, we'll elaborate. I'm going to elaborate all these codes for you. Okay. So starting off with the civil court system. Starting off with the civil court system. So the very first court under this area, civil court system, that is mentioned over here is magistrates court. Magistrate court. That is the very first court. Magistrate court. Magistrate court basically, but remember, you need to remember this, that magistrate court basically is a criminal court. It is not a civil court. It is a criminal court, and it is mentioned over here only because it has some authority in civil matters and civil claims. Otherwise, it's a criminal court. Otherwise, it's a criminal court. But it has some authority regarding civil matters in civil matters. For example, one of its division which deals with family matters, like matters regarding any family member. It could be spouses, it could be children, it could be guardian issues, and also areas like council tax, like local authority charges, like electricity issues, and all those areas. So it has some authority, magistrate court, in some instances here, some civil courts as well. Otherwise, it is not a civil court. It is not a civil court. The very first civil court is basically, yeah, as you can see on this slide, the main civil court is county court. The very first civil court is county court. County. county court. So, county court is basically known as or pronounced as first instance for civil claims. First instance court, first instance court for civil claims. So, if you have any civil claim which is between two individuals, it is for the very first time brought up into the English legal system, civil court system through the county court. First instance for the civil claims is the county court. Cases like contract, cases like tort, cases like land related, tenancy related, and the first hearing is done in this court. First hearing is done in this court. There are basically two judges who sits in the county court. One judge is basically district judge. One district judge sits in the county court. Then there is one judge, which is the circuit judge. One circuit judge sits in the county court as well. So there are two justices, two judge, one district judge, and one circuit judge. You can see all this from here as well. One district judge and one circuit judge. So whenever the claims are brought, or the civil claims, they are for the first time brought into the English legal system through county court, and whenever the claim is a small claim, whenever the case is a small claim case, well, small claim cases are cases with not more than an issue of not more than £10,000. When they are at first brought to the to the county court, very first court of the civil court, county court, well, they are heard by the district judges, and the district judge gives the decision on small claims cases, and the circuit judge gives the decision on the fast track. It could be small claim or small track, fast claim or fast track, which is cases between 10,000 to 25,000 pounds. Any dispute between 10,000 to 25,000 pounds, fast track cases, whenever they are brought to the county court, well, they are heard by the circuit judges. Circuit judge gives the decision, and then there are multi-track cases. Well, multi-track cases are cases which are more than 25,000 pounds. They are also brought to the circuit judge, and circuit judge hears the cases, and the claims are sent over here, and then the circuit judge gives the verdict. And from the county court, as you can see, from the county court, the claims are sent to the high court. Claims are sent to the High Court. It can even be sent to the Court of Appeal, as you can see from this leapfrog diagram and arrow, but first they're sent to the High Court. From here, the claims are sent to the High Court. The next court in the English legal system, well, that is High Court. High Court. Whenever the case is sent to the High Court, well, there is one High Court judge in the first instance, one High Court judge sitting alone in the first instance, and then it is forwarded to the related division, and we have three divisions of the High Court. As you all know, we have three divisions of the High Court. One of the division is QBD, one of the division is QBD, one of the division is Chancery, and one of the division is Family Division. Three divisions in the High Court. Well, QBT hears all the cases regarding contract and tort civil cases brought forward, and QBD division listens to all these cases, and family division listens to the cases, family matrimonial matters regarding individuals in a family. It could be brother and sister, it could be spouses, it could be children, it could be guardianship issues. All such matters are dealt with in the family division of the High Court, contract and tort in the QBD, and the rest of the matters are dealt at Chancery. Well, those are not related to contract or tort and family related issues, like issues like cases regarding trust, cases regarding company law, cases regarding partnership law, cases regarding land, tenancy, cases regarding insolvency. Well, all these cases are heard over here. And from here, the cases are sent from High Court. The cases are sent either to the Court of Appeal or to the Supreme Court. As you can see from the diagram, High Court, the cases are sent to the Court of Appeal or to the Supreme Court. The next court in civil court system is Court of Appeal. Court of Appeal with the civil division of Court of Appeal has two divisions, civil division and criminal division. The civil division of Court of Appeal has three Lord Justices, and they hear the cases that have been heard before in either county or High Court. Well, it is never the first instance case. Well, the Court of Appeal is not the first instance for any case. You cannot come directly to the Court of Appeal for any case. For any case, it only listens to the cases which have been heard before, either at the county court or at the High Court. High Court. Court of Appeal is never the first instance, and they cannot directly be contacted. So they give their verdict on the cases that have been heard before, either in the county or in the High Court. Like Supreme Court, the highest level of hierarchy of the English legal system, Supreme Court. So again, the case cannot be brought directly to Supreme Court. The case can never be brought, as you all know, directly. The case cannot be brought to the Supreme Court. It must have been heard before in any other courts like county, High Court, or the Court of Appeal. And then the Supreme Court gave their verdict. It was previously known as House of Lords. The previous name was House of Lords for Supreme Court, and in 2007 the name changed and it was changed to Supreme Court, the highest court in the English legal system, both for civil and criminal jurisdiction, as you can see. As you can see. So this is the area for civil court systems. And like this, there is this criminal court system as well. criminal court, and it begins with magistrate court. Criminal court, and it begins with magistrate court. So, talking about the criminal court system or hierarchy, criminal court system or hierarchy, well, it begins with magistrate court. Magistrate is the first instance court for any criminal act. First initial hearing is done in this case. So it is going to be the first instance court for criminal cases. Like county is the first instance court for civil claims. So three types of claims are mentioned. One of them is known as summary offense. Summary offense is a smaller crime. Summary offense is a small crime. Small crime. And the hearing of these cases are basically done in the magistrate court, and even the decision is given because the decision is not that much serious. The remedy is not that much serious as it's not a big crime. So summary offences are being heard and the decision is given in this court, magistrate court. Then there are some serious offences which are known as indictable offences. Indictable, a major offence. A major offence. So for indictable offences, it is just the first point of hearing, first hearing. The decision is not given over here. Why? Because in magistrate court, the decision is given by one district judge. It has three. It consists of lay magistrates and one district judge, but it has no jury. There is no jury in magistrate court. And for indictable offences, we need a jury. So the initial hearing is done and then it is passed to the Crown Court because the jury sits in the Crown Court. Jury is a collection of people. They do their analysis, they do their work, and then they give the judgment. So for indictable offences, we need the decision from the jury. It is passed to the Crown Court. And for indictable major offences, well, you can have the first hearing over here. For summary offences, the decision is made over here. Then there are offences tribal either way. Tribal either way offense. Either way as in, do you want the judgment from the jury? Do you want the judgment from the jury, or do you want the judgment from the judge alone sitting at the magistrate court? You can go either way. Well, the defendant decides, is not satisfied with the decision of the judge, well, he can claim in a Crown Court for the jury's decision. From here, the appeals go to Crown Court or the relevant division of the High Court. High Court division, and that division is, the relevant division is QBD. QBD deals with the criminal appeals. So you can see magistrate court, the appeal go to High Court or the relevant division of Crown Court or relevant division of the High Court, that is QBD. Next court in the criminal system is Crown Court. Important court, Crown Court. Court with only and only criminal jurisdiction, and a jury sits here. A jury sits here because it deals with major crimes and indictable offences, which is a big offence, and it is presided over by one judge. It is presided over by a judge, but the jury sits in here. Case is heard by the jury. Case is heard by the jury, and the jury analyzes it and gives the verdict. Well, the jury decides whether the person is guilty or no. Jury decides whether the person is guilty or no. Or in the High Court, the relevant division is QBD. QBD takes up these cases, and they hear appeals from magistrate court and give their verdict, and the appeals from here can be taken up to the Court of Appeal. Court of Appeal and Court of Appeal, the criminal division. Court of Appeal has two divisions, civil division and criminal division. Of course, the appeal from High Court, Crown Court goes to the criminal division of the Court of Appeal. Again, three Lord Justices sitting over there, and they hear the appeal. Not the court of first instance for criminal as well. They hear the appeal and they give their decision, which could always be appealed at the Supreme Court as well. So Supreme Court, again, different justices sitting over there, 5 justices, and they hear the appeal from Court of Appeal and High Court. They hear the appeal from Court of Appeal or the High Court, and then they give their verdict. So this is basically the structure of court in civil and criminal jurisdiction. There are certain other courts as well, like ACCA, European Court of Justice, it deals with the action between European Union and the states. UK was once part of the European Union, so it deals with the action of the European Union and the state. And the cases in these courts are brought by the national courts. Cases are referred by national courts. The national courts of those countries would refer the cases to ACCA, and they are going to decide on it, and there is no appeal. You cannot go for any further appeal to any other case. That the decision is final. If you ask for the decision from ACCA, it is final decision. Just like ECHR, European Court of Human Rights. Just like European Court of Human Rights. Again, the cases are referred by the national courts, and human rights give the verdict, and you have no further right of appeal. Some other courts like Judicial Committee or Privy Council. Privy Council. So what is that? Well, Privy Council is basically the highest court of appeal for basically certain Commonwealth countries. Certain countries fall under the regime of Commonwealth countries. Commonwealth countries. And the proceedings, basically they take up their cases over there and they give the proceedings both on civil and criminal jurisdiction. Both cases are heard over there. Again, no further appeal. No further appeal. So all these courts, they are really important. Examiner would definitely make it a point that you ask a question on these courts. Let's see a question like this. Which of the following statements regarding Supreme Court is correct? Well, this is a question related to judicial precedent. We'll talk about it later in the area. Next question. Which of the following courts deal with civil law matters only? Crown Court is a criminal court. Magistrate Court is basically a criminal court, but some civil cases as well, claims as well. County Court. The answer is County Court. Which of the following courts appeals from Magistrate Court? Basically, the word should be which of the following courts hear appeals from Magistrate Court? Well, County Court, County Court, Crown Court, High Court. There are three courts, and you need to decide that which of the following courts hears the appeal from Magistrate Court. Well, Magistrate is basically criminal court, so County Court is not the option. Crown Court, yes. High Court, yes. You can see it in the flow chart as well. What is the final appeal court in the UK? Supreme Court. Supreme Court is the final appeal court in UK. So we're heading towards the break and we'll continue at 11:10. Okay, students, welcome back. So let's just resume this session from where we left. So if you have any questions, you can put that in the question box. Well, the things that I've written on the notepad, well, you are supposed to note that down as I'm writing all those things. So you're supposed to note that down as I'm writing all those things, and I'll give you time to jot those things down. And for the rest, you have the slides in front of you. And custom means, there's another question, custom. Custom means the local laws that are being followed, that has been followed. Well, I think the recording of the webinars would be available. I think they're being recorded. Okay, so moving on, these are the questions so far, and you can put up the questions while we are studying. Okay, so the next area in regarding the English legal system are the certain sources of law, and we'll be discussing about the sources briefly because you have all the idea of the sources, and then we'll be moving on to the next topic, that is contract law. So once we have decided on all the codes and all the different types of laws, well, the next thing is that um, how the judges are supposed to give the decisions. Well, there are different sources to that. Well, the number one source is known as judicial precedent. Judicial precedent. Precedent is set by a previous case, and the next court is supposed to follow that precedent. So it basically says that the judge has to decide in accordance with the existing case law. Now, case law is that the case that has been heard before. What is case law? The basis of case law is that the law is interpreted by the courts and evolves as the cases are heard. So whenever there's a decision, there's a case that has been heard before, and then a case comes with similar facts. You're supposed to give the same decision. You're supposed to follow the precedent. You're supposed to follow the precedent, and you're supposed to give the same decision. Follow the precedent as identified in the case law, case laws. But four factors are basically there that you're supposed to see. Number one, it should be based on certain propositions of law. The previous decision should be based on, you can see the rules written over here as well in this box, proposition of law. It should be, the proposition of law should have been followed. Number one, the material facts should be same. If the facts are not same, judicial precedent cannot be followed, and material facts should be same, and you have to follow the decision of a superior court. Superior court. For example, Court of Appeal would follow the decision of Supreme Court, and High Court would follow the decision of Court of Appeal. County would follow the decision of High Court. So it has to be the superior court, and ratio decidendi should be followed. Ratio decidendi should be followed. What is ratio decidendi? Ratio decidendi is basically the basis of decision, basis of previous decision. So if you're giving the same decision, by following the precedent, you're giving the same decision, so the basis should be same as well. The ratio decidendi should be same as well. Another word that is used over here sometimes is obiter dicta. Obiter, let me write it clearly. The other word that normally used over here is obiter dicta. These are the statements that are just said by the way during the cases. Well, they are not supposed to be followed. You're not supposed to follow obiter dicta. However, you're supposed to follow ratio decidendi. So these four factors are really important when you're following judicial precedent, and you have to follow the precedent, and this sets the basis for the next case laws. The decision that you are going to make now would be the precedent for the next coming courts. Then the next source is legislation. Legislation, law. Doctrine of judicial precedent, principle of judicial precedent, four factors you need to know. The next source is legislation is the law made by the parliament. Well, how does the parliament make the law? Legislation is the next source. Well, this is the law made by the parliament. Parliament basically has three parts. House of Lords is the upper part, the upper tier. House of Commons is the lower house of the parliament, lower part of the parliament, and monarch, it is basically regarding queen. So whenever you're going to make a law, you need to pass it all these three stages: House of Lords, House of Commons, all these areas, the upper part, the lower part, and the monarch. You need queen's approval, you need royal assent. Okay. Royal, what I've written, royal assent, queen's approval, royal assent. So three areas. Okay, so whenever you write down a law, you need to pass that law through 5 stages in both of these houses, upper part and lower part. 5 stages that you have to follow, and those 5 stages, as you have studied in your syllabus, the first stage is the first reading. It just involves the first reading. The law, which is written on white paper, brown paper, it is basically just read in front of the house. First reading, nobody is allowed to say something, to debate. Then the house meets again. In the second reading stage, the law is read again, but people are allowed to debate. People are allowed to vote for the changes and all. And to make those changes, there's another stage, that is committee stage. Well, in the committee stage, what happens, a committee is formed, mostly of 20 people, and that committee is asked to make those changes, make those alterations to the law. Alterations to the law. Then we have the report stage. After the alterations are being done, the law is again reported to everybody involved in the house, either House of Lords or Common, and we say that we are seeking your approval. Once the House approves that, there comes the final stage, and that is known as third reading. Third reading. Then these 5 stages are basically again followed in the House of Commons. After these 5 stages from both of the houses, we go for Queen's approval. Initially, previously, Queen used to do that. Now, Lord Chancellor can sign for it, and his 2 peers, 2 fellows, 2 peers of Lord Chancellor and the Lord Chancellor, if they sign it, it is considered as Queen's approval, monarch's approval. Lord Chancellor plus his 2 peers. So it would be considered Queen's approval. It would be considered royal assent. So this is all about legislation, and then we can use interpretations as well. Interpretation is basically used for any ambiguity. Interpretations are used to remove any ambiguity in the law. Anything is not clear, so any ambiguities, they are removed through interpretation. Interpretation could be done through certain rules, or interpretation could be done through other aids as well. So the rules that were identified under interpretations, well, one of the rule was literal rule, which basically gives the plain meaning, the words their plain meaning. Under, if a law was interpreted under literal rule, the words were given their plain meaning, and which would basically could be absurd as well when deciding the remedy for that case. So for that instance, there came certain other rules, like purposive rule. Purposive rule says that no, we are not going to go for the plain dictionary meaning of the words. We are going to see that which purpose this law has been made for, and we are going to interpret it in that context. Mischief rule was also an example of this. Mischief rule. Mischief, the act prohibited by law for what the law was basically made for. So it is not going to be given their plain meaning. It is going to see that whether that mischief is being prohibited by this law or no. So there's certain developments in the rules, and these are the developments that you must have studied and you should know. Moreover, for interpretation, we can use other helps as well, other aids as well. Some of them are intrinsic aids, intrinsic from internal, and some of them are extrinsic aid. For interpretation, to remove any ambiguity, for example, you can put a long title in the act. Long title. Long title would be intrinsic aid, and this is going to help us. Or you can put an introduction or preamble. This is also going to help us understand the law. Extrinsic would be from external, as the word Hansard is used. Hansard is basically the discussions in the court. Well, certain things can be made clear through discussions in the court as well. So Hansard is an extrinsic aid. So these are different sources of law, and you can use these sources of law for deciding on the case. So contextual rules, in which context the law is made, legislation, statutory interpretation, and all these things. Let's have a look at some questions. Which of the following regarding judicial precedent is correct? Court of Appeal is bound by judgment of the Supreme Court. Well, this could be correct. Court of Appeal is bound by the judgment of QBD. No. You are bound by a superior court. Court of Appeal is bound by judgment of Chancery Division of High Court. No. Court of Appeal is bound by judgment of Family Division of High Court. No. The answer is A. You are bound by a senior court, by a superior court. Which of the following statements regarding Supreme Court is correct? It is bound by, as we know, Supreme Court is the highest court. So it is bound by its previous decisions, but it may depart if they are considered to be wrong. Is it bound by its previous decisions? It is always bound by its previous decisions? No. It is normally bound by its previous decisions, but may depart when it appears to be right to do so. C is the answer. The court is bound by its own divisions as well. However, it may depart from this rule. So, students, this was the first area. Well, let's have a look at a few more questions. This is how the examiner would test your knowledge. You need to have a full knowledge of these technical areas. Which part of a legal judgment establishes the precedent that is to be followed by a lower court? Ratio decidendi, the facts that are considered important to the judge, or obiter dicta. Ratio decidendi. It is a little misspelled over here. The word is ratio decidendi. Which of the following is not a form of delegated legislation? Statute, statutory instrument, or orders in council? Well, what is delegated legislation? Before that, we need to see that what is delegated legislation. Well, delegated legislation, the parliament has to make the law. And how does the parliament make the law? Like this is how the parliament makes the law. And it, you can see, could be a long procedure, a lengthy procedure. For that sake, the parliament is allowed to delegate. The parliament has allowed to delegate this area under delegated legislation. Delegated legislations. Well, what is delegated? Formation of law, such an important issue. You're making a law and you have delegated it. Delegated to whom? Delegated to MPs, members of the parliament. You say that they can make a statutory instrument. They can give their verdicts on statutory instrument, on bylaws, on rules of the court, on professional regulations, on orders in council. So we have allowed the delegation, but we need to provide certain controls for them as well. For example, a scrutiny committee is provided, which basically scrutinizes the decisions of the delegated legislation. However, it is still a mean used to basically used as a power which can make laws. Delegated legislation. And human rights, we have talked about it, 1998, it was an act and incorporates European Convention on the Protection of Human Rights. Appeal can go to human rights, but from the national courts. And if we take it to the court, EC, European Court of Human Rights, then that is the final verdict. There's no further appeal. So, going back to the previous slide, which of the following is not a form of delegated legislation? Statute, statutory instrument, or orders in council? The answer is statute. Statute is the detailed law made by the parliament. Statutory instrument, order in council, yes, it is delegated legislation. some other random question. Which of the following is the prosecutor in a criminal law? Who brings up the case? State. Who brings up the case in criminal law? Government. State. Which of the following describe the standard of proof in a civil law? How does a standard of proof is provided in a civil law? Beyond reasonable doubt. That is for criminal law. Balance of probability beyond all probability. Answer is B. Balance of probability. Standard of proof is not that much. Not that much standard of proof is required for civil law. The Chancery Division of High Court hears cases involving which of the following? Contract law, trust and mortgages, matrimonial, adoption. It is not contract law, it is not matrimonial, it is not adoption, it is B. Eliminate the incorrect answers and go to the correct answer. In the criminal law systems, an appeal regarding a decision by a magistrate court could be heard by which of the following? County Court, Crown Court, Court of Appeal, Supreme Court. Criminal law, well, Crown Court. Crown Court is the answer for criminal law. Which of the following types of court decisions occurs when a court higher in the hierarchy overturns a verdict of a lower court in the same? So there are three words being used: reversing, overruling, and distinguishing. Whenever a case is taken up higher to a higher court, whenever a case is taken up to a higher court, what happens there? Well, three possible things. A lower court appeals to a higher court. Well, three possible outcomes. Number one is reversing. Number two is overruling, reverse, overrule, or distinguish. Distinguish. Well, in reversing, the court says that the legal rule decided in this case is wrong, and the overturns the decision in this case. Whereas in overrule, again, they decide that the legal rule decided is wrong. Again, they say that the legal rule is wrong, and they say that we are not going to follow in the coming case, in different case. In different case, they say that we are not going to follow this rule. We overrule it. But in reversing, it overturns in the same case. In the same case. Same case. And for overrule, it is not followed in the different case. And distinguishing is when you tend to avoid precedent. You're asked to follow that precedent, but you say that no, you're not following it. You can distinguish it. You can say the facts are not same, this is not same, but in any case, you say that no, we're not following it. We are not following it. So if the question comes up, which of the following types of court decisions occurs when a court higher in the hierarchy overturns verdict of a lower court in a similar case? The answer is, well, reversing. A. Which of the following types of legislation affects specific individuals or groups? Private. When we talk about specific groups, it is private. So far we have talked about so many different areas under the English legal system, and the idea is that we need to that you should be okay with the knowledge so that you can eventually give the correct answer when it comes up in the exam. It is going to be an answer with certain options, and you'll have to choose one option from there. So this was all about English legal system. Let's move on to the next area of the syllabus, and that is another area that you need to know, and that is contract law. You must have studied it in your F4 throughout, an important area, and that is contract law. We'll just quickly go through certain topics under this area, and we'll be talking about questions regarding this topic. So contract, as you know, is a legal agreement. And let me just see if you have any questions. Okay, so Lee has a question. How can I review the notepad? Well, the recordings, the lecture is being recorded, I guess, and will be provided with the recordings. And you can review that. And as I told you, you can jot down the main points as I am writing them down. And so, no more questions right now. Okay, so contract law. Contract law. Contract is a legal agreement, and for any normal agreement to be legal agreement, we know that there are three things that should be present: offer and acceptance, consideration, and intention. We'll be looking at all these three areas, and then there's certain factors that should also be considered when forming a contract. For example, a first factor is of capacity. Capacity means that the parties should be under capacitation if they want to perform a certain act in a contract. An individual, as you all know, could come under incapacitation if he or she is a minor. With a minor, you can do contracts of necessities. However, the question of capacity can come up if the person is a minor, the person is of unsound mind, or under some kind of intoxication. So the person should be in proper capacity if you want to form a contract with that person. When we talk about certain forms of contract, not all contracts are written. Contracts could be oral as well, could be through action or conduct as well. However, they can be written as well. This is not a must for all the contracts, but they can be written as well. They can be written on a particular deed, like land. A contract of land should be written on a particular deed. They can be just in writing, or they can be evidenced in writing as well. Evidenced in writing as well. And legality is an important factor. If you want to enforce a contract, it has to be legal. The consent should be genuine. These are certain factors and certain elements of contract law. Starting off with the very first element, and that is offer. First portion of the very first element, contracts and factors affecting the contract, offer and acceptance, consideration and intention. Capacity, form, content. Content means terms, genuine consent, legality. Offer is a definite promise to be bound in specific terms. What is offer? Offer is a definite promise to be bound on specific terms. The one who offers is known as offerer. To whom an offer is being made is known as offeree. So when an offerer is willing definitely to be bound on specific terms with the offeree, that is an offer. That comprises an offer. That comprises an offer. Well, an offer could be what could be an offer? Well, see. So offer does not have to be made to a certain particular person. Well, offer basically what or to whom you can place an offer to. It could be basically be to one person. Offer can be made to one person. Offer can be made to group of people. Offer can be made to the world at large as well. You can make an offer to the whole world as well, as it was decided in Carlyle versus Carbolic Smoke Corporation. That was the deciding case. Well, offer can be made to the whole world as well, and it has to be, but it just has to be clear if it has to be enforceable. It just has to be clear. And what does not constitutes an offer? What is not an offer? Well, supply of information. If just supplying information until and unless it is between a bargaining, it at that times it could be an offer. Otherwise, supply of information is not considered an offer. Statement of intention, a statement merely just describing your intention that you are deciding to place an offer. It is not an offer. Invitation to treat. Invitation to treat, when you invite people to make offer. For example, under auction sale. You say that it's going to be an auction 9 a.m. tomorrow. That is not an offer. The people are going to come and put forward their bid. The bidders are the offerers putting forward their bids as offer. Inviting them is invitation to treat. Or when you announce the tender, announcing the tender is not an offer. The quotations sent by the suppliers is an offer, and we are going to accept or reject them. Even advertisement is not an offer until and unless it is with a reward. Then it is known as unilateral offer coming from one side. Then it is known as unilateral offer. Even advertisement is not an offer. Exhibition is also a form of invitation to treat. It is also not an offer. So these are the things which are not going to be considered offered in the eyes of law. An offer can be terminated. Offer can be terminated whenever either of these would occur. There are 6 instances when an offer can be terminated. An offer can be terminated by rejection. If the offeree says no, so that is the rejection. An offer is terminated. An offer can be terminated by counter offer. Counter offer. If you put forward an offer of 500 and the offer you put for says that I'm willing to take it up at only 450, that is a counter offer. That is a counter offer. And counter offer is the final rejection of the original offer. Counter offer is the final rejection of the original offer until and unless it is request for information. Request for information, as you all know, is not counter offer. Is not counter offer. An offer can be terminated by lapse of time. After a reasonable time, the offer is considered terminated. The offer can also be terminated through revocation when an offerer takes back his offer. Can he do this? Yes, he can do this. He has to satisfy two conditions. It should be before acceptance and it should be properly communicated. Communicated to whom? Communicated to the offerer. Sorry, offeree. Offeree. To whom you have communicated your offer, you're going to communicate your revocation to that person as well. You have to satisfy these two conditions. Moreover, failure of a condition. If an offer is conditional, if an offer comes up with a condition, the condition fails, the offer fails. Condition fails, offer is terminated. For example, early enrollment discount. You cannot claim early enrollment discount 2 months after the badge has started. It comes with the condition. And death. Well, death of the offeree to whom an offer is being made automatically terminates the contract. However, the death of the offerer, as you all know, it should be communicated by its executors to the offeree. It only terminates the offer if the death of the offerer is communicated to the offeree. So these are certain issues regarding offer. Let's see what the examiner is asking. Well, in the context of contract law, what will a display of goods in a shop window generally constitute? If you're exhibiting certain goods in a shop window, is it offer? Is it invitation to treat? Or is it statement of intention? Well, it is invitation to treat. I told you, exhibition and display, this is invitation to treat. Which of the following is not an essential element of a valid simple contract? Contract must be in writing. Parties must be in agreement. Each party must provide consideration. But are all contracts written? No, it's not a must. So A is not a must. A is not essential. What else could the examiner ask? Which of the following is not required for revocation of an offer? It must be in writing. It must be made before the offer is accepted, and it must be made by the offerer or a reliable third party. Well, A. A is not a must. The next two are the conditions. What is the principle of effect of a counter offer? It destroys the original offer and replaces it with a new offer. It creates a binding contract. It creates a binding contract based on the terms of the original offer. Well, counteroffer is a rejection of the original offer. The definition of counteroffer is it is the final rejection of the original offer. A is the answer. So, just like offer, there are certain rules regarding acceptance as well. So acceptance acceptance. So what is acceptance? Acceptance is basically a positive response, a positive response from the offerer. Sorry, offeree, to whom an offer is being made. A positive response from the offeree to whom an offer is being made. And the acceptance could be through words, it could be through conduct as well. However, what is not an acceptance? Silence. Silence is not acceptance. And counter offer in nature is also an offer. It is not an acceptance as well. Counter offer is not acceptance as well. What else? What else do we have? Counter offer is also not acceptance. Subject to contract. If the party says, well, the contract is still to be written, then that is subject to be contract. The contract still to be decided. For example, a contract of land on a particular deed, and it is not done on a particular deed, it is still to be done. Well, that is not acceptance. That is not regarded as acceptance. So acceptance is a positive act by a person to whom an offer has been made, normally known as offeree, and it has to be unconditional to make the contract binding. Acceptance must be communicated to the offerer or it is not effective. The communication of acceptance is really important. Acceptance made by express words and a request for information is not acceptance. Where the post is a valid mean of acceptance, at what point? Well, for acceptance, we need termination of offer is discussed. Well, for acceptance, we need to discuss few points before going on to the next question. Acceptance, well, that's not the rule for offer, but for acceptance, communication is really important. Communication is a must. The communication of acceptance is a must to bring a binding contract into effect, and there is just one instance when there is a waiver, and when you are said that it is okay not to communicate your acceptance, and that is for unilateral contracts. Contracts like Carlyle versus Carbolic Smoke Bowl Corporation, which comes with a reward, So in those contracts, acceptance is not a must. They can even not be revoked. You cannot revoke them as well. Otherwise, acceptance is always communication of acceptance is always a must. And if you want a prescribed acceptance in any prescribed mode, you have to specifically mention that by putting some stress that only and only this mode is going to be used. Otherwise, other modes can also be used if they are within time. If you have not stressed upon it enough and the other modes are used and they are within time, expedient enough, then you can basically go for the acceptance. Then you can go for the any mode for communication of acceptance. If you want to prescribe a mode, make sure specifically you are saying that only and only this mode is considered. Like postal rule, there is a rule, postal rule, and both the parties know that the acceptance is coming through post. So there is a rule that number one, you need to know, you need to have an understanding that yes, the acceptance is coming through post. And in that scenario, in that case, even when the letter is late or even lost in the post, the acceptance is considered valid. Why? Because what we see is the dispatch date of the letter, not the receiving date of the letter. That is postal rule, and that are the rules regarding communication of acceptance. So let's have a look at a question. Where the post is a valid mean of acceptance, at what point will the offeree have been held to have accepted the offer? When the letter of acceptance has been written, when the letter of acceptance has been correctly addressed, its postage paid and posted, or when the letter of acceptance is received. As I told you, receiving the letter of acceptance is not a precondition if a postal rule is followed. It is not a precondition if a postal rule is followed. So what should be the point when the acceptance is valid? When the letter is posted. When the letter is posted, the answer is B. Another question, in the context of contract law, which one of the following statements is not correct? Acceptance must be unqualified and unconditional. Well, that is correct. If you want to make a binding contract, acceptance should be unconditional. You cannot say, okay, I'm accepting these terms, but this. That is not acceptance. It has to be unconditional. Acceptance can be oral, written, or by conduct. That is also true. As a general principle, acceptance is not effective until it is communicated. That is also true. Acceptance can be terminated by revocation. No. Offer can be terminated by revocation. Once you have given acceptance, a binding contract is being made. Termination of offer. 6 rules for the termination of offer. Posting a letter is not sufficient. It must be received. Well, that is only for offer. When we talk about acceptance, the postal rule applies. The postal rule applies in acceptance. So these are certain questions in regarding offer and acceptance, and the next area is consideration. And let's have a look at the question panel. Okay, so we are heading to another mini break, and I'll be back in 5 minutes. We'll be resuming at 12:05. Okay, welcome back. Let's just resume from where we stopped. So these are the rules regarding offer and acceptance. Well, the next is consideration. The next area is consideration. Consideration and promissory estoppel under the topic of promissory estoppel under consideration. Okay, so could you please let me just read some question? Could you please guide if final preparation should be done from BPP? Yes, BPP. You can follow any text. BPP is a thorough text. You can follow that text and you can follow these slides for the final preparation. Well, you said you have done the preparation from Kaplan. BPC is necessary. You can follow any text. Any text can be followed. So if you have done Kaplan, you're good to go. But you need to have knowledge of all the technical areas. Okay, so that were all about the questions. Let's just move forward. Let's just move forward. Consideration and the area under consideration, which is of prime importance, is promissory estoppel. Area of promissory estoppel. So consideration is some right, interest, profit or benefit accrued to one party or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other party. So what the either party gets out of the contract is the consideration for that party. For example, party A transfers goods to party B and party B transfers money to party A. For consideration for party B would be goods, consideration for party A would be money. Considerations, there are different categories of consideration. So for a valid consideration, consideration could either be executed consideration or executory consideration. For executed consideration, as I just mentioned, the consideration passing from party A and B, well, both of the parties must be passing their considerations at present. Party A should also be giving the consideration at present and party B should also be giving their consideration as present. For example, when you sell goods on cash, so the company gives the goods and company receives the cash. The entry that we put in our ledgers is cash to sales, executed consideration. However, for an executory consideration, the element of future comes in. Party A passes the goods under executed consideration. However, Party B would pay after 2 months. So the contract is done, considerations have been decided. The only difference is that it has been left for the future. It has been left to be executed in the future. As the name says, executory consideration. Executory consideration. One of the party must say that they'll be performing their part of the contract, their part of the consideration in future. That is executory. Executory consideration. Past consideration is normally considered invalid in the eyes of law. Invalid consideration in the eyes of law. Say for some certain circumstances, for example, if it is in the form of check or bill of exchange. So consideration is that when the party basically have certain rights or liability. So if one of the party basically gives some waive off some rights, gives some waiver to the other party, gives some waiver. Well, for example, they were to get £1,000 and this from party A, the business says that okay, we will accept 800, we will give you a waiver of 200. We will give you a waiver of 200. So this is known as waiver of existing rights. This is known as waiver of existing rights. Waiver of existing consideration, waiver of existing rights. These waivers, at times you get something in return for these waivers. At times these waivers are supported by considerations. You also get something in return. The business is also getting something in return. For example, if it is a debtor and you are asking for early payment, that is what you are getting in return. For example, it could be third party part payment. What are you getting in return? Well, reduction in loss is what you're getting. But at times it is not supported by consideration. You are not getting anything in return and you're just promising that, okay, we are giving you waiver. Normally business do this because of the circumstances. At times they do as a favor as well, but normally they do it because of the circumstances. The circumstances that prevail. And when the person has made the promise that, okay, I'm giving you the waiver and I don't want anything in return, then law is going to stop you from going back on your promise under the principle of promissory estoppel. Law says that, okay, you have given the promise, now you cannot take back your promise. Yes, you can suspend it. You can say, okay, the promise is not for future. But you cannot go retrospective and take back your promise. Why? Because there's a principle, promissory estoppel. If anybody, if the if this is you, you are the promisor, you have given the promise, and this is the promisee. And promisee is saying, well, I didn't ask him to give me the waiver. He gave it by himself. And now he's taking it back. Protect me under promissory estoppel. Is the law going to protect the defendant? Yes. Law is going to protect the defendant because defendant is a promisee, is saying that he is the promisor. He promised me, stop him from going back on his promise by this principle. Defendant is standing in the defense court as one of the factor of promissory estoppel says that it can be used as a shield, not sword. This is an important factor. You can use promissory estoppel just to defend yourself, not to attack. And the promise has to be entirely voluntary. Voluntary. So this is the flow chart that is going to help you understand waiver. It is at times supported by consideration like this. It is at times not supported by, when it is not supported by consideration, promissory estoppel applies. Promissory estoppel applies. Consideration, valid consideration, invalid consideration, promissory estoppel. The next area is intention. Intention. Intention, and the important area under it is privity. Privity. So if the intention is not clear, you're supposed to use two assumptions, rebuttable presumptions. These presumptions are rebuttable. They can be refuted. And if the intention is not clear, the court is going to assume. For all the domestic slash social nature contract, the court is going to assume that if the intention is not clear, the parties, they do not intend to make it binding. If the contract is of commercial nature, then the court is always going to assume, even if it is not mentioned, the parties do intend to make it legally binding. So these are the assumptions that the court is going to make when the intention is not clear. Moreover, the court has said that it is rebuttable. It can be refuted. You can prove us wrong because we are also assuming. So, until proved otherwise. So, I am writing this phrase on both the sides. Until proved otherwise. Domestic social nature contracts never considered to be legally binding until proved otherwise. Commercial nature contract always considered them to be legally binding until proved otherwise. So this is the basic rule for intention. But we need to consider privity as well. Privity. The important area is privity. Privity of contract. So it is between individual parties. Whatever is happening, it is happening between individual parties. And parties to the contract have rights, and party to the contract have liabilities. Only they have the rights, only they can enjoy the rights, only they can be asked to fill up the liabilities. Third party has no right. Third party has no right except for certain areas. There are certain exceptions to this rule when third parties are given the right. So privity says whatever is happening, it is happening between the individual. Only the parties to the contract, for example, party A and party B, they have enforceable rights. They have liabilities. Third party has no right whatsoever. Third party has no liability whatsoever. This is the concept of privity. However, this is a general concept and it has certain exceptions. At times, third parties have rights. For example, in valid assignments, when you have given your right to a third party. For example, in a collateral contract, when you're not related directly, but you're related indirectly. For example, in agency, we'll talk about agency tomorrow, inshallah. Agency, there's a principal, there's an agent, and there's a third party. The contract is being written, being signed by the principal and third party. Agent is a agent is an intermediary. They have no right and no liability. But at times, agency law says that agent will take up some liabilities as well. So this is how it is against privity, privity of contract. Only a person who is a party to a contract has enforceable right or obligation. Third party, only they have no right or obligation, just in some exceptional circumstances. For example, third party can sue in another capacity, collateral contract, valid assignment, foreseeable loss to the third party. When you see that there is a foreseeable loss to the third party, then you can claim with the third party, implied statutory exception, agency, restrictive covenant. Whenever there's a covenant mentioned, for example, restrictive covenant runs with the land, and you have to follow that thing even if you're a third party, because even if you're a third party, you could be liable for the breach of contract. So you need to know all these exceptions written in this box. So let's have a look at certain questions. We skipped some questions in the previous slide. Have a look. J promises to pay a reward for the return for a lost phone. M finds the phone and returns to it. Which of the following types of consideration has M provided? M found the phone and returned to J. Executed consideration, executory consideration, past consideration, or insufficient consideration. It is not D, insufficient consideration. It could either be A, B, or C. Well, J says, okay, I will pay a reward. Reward is a promise for some monetary thing. So what J is saying is executory. What M did is executed. Executed consideration. Which of the following statements about executory consideration is correct? It is consideration that is yet to be provided. It is consideration that has already been provided. Well, that is executed. It is considered consideration that is insufficient in the eyes of the law. Well, A is the answer. It is consideration that is yet to be provided. Then we talk about privity and vast majority of contracts are simple. What is the meaning of word simple? Term of the contract are set out in writing. Contract does not need to be in any particular form. Contract contains fewer than 10 provisions. Well, B, simple contract does not have to be in any form. These are certain questions regarding privity. So a contract is formed, offer is there, acceptance is there, consideration is decided, intention is decided, privity has been set. Now, there are certain terms that could be followed, and specifically regarding exclusion clause. Terms regarding exclusion clauses. So between terms and if there's a contract and there are certain statements mentioned on the contract, those statements can either be termed as representations or they can either be called terms. Represent term is an important statement. Representation is not that important as term. Term is decided at the formation of the contract, at the formation of the contract. At the time of formation of the contract, the term is set up and it mostly becomes the part of the contract. Well, representation is something that is being said before the contract is being made, and it may or may not become a part of the contract. The only objective is to induce the formation of the contract. It could be used that so to convince the other party so that they eventually comes up with the contract with us. Formation of the contract. The terms are not that important and they're discussed way before the formation of the contract. Sorry, representations are not that much important and they're discussed way before the formation of the contract. Terms they're really important and they're discussed at the time the contract is made. And terms have different sources. They could be express terms written expressly, or they could become a part of the contract by implied terms. It could be implied through custom, it could be implied through statute, or implied through the court, through the judge. Then we have certain types of the terms. Some of the terms are major terms and some of the terms are minor terms. A major term is known as condition, and a minor term, as you all know, is known as a warranty. Condition and a warranty. If a party breaches or breaks a major term, they have to face the remedy. That would be financial damages at the first place, and that could even result in the termination of the contract, which is not the case for warranty. The only remedy available for warranty is the financial damage. You just get one remedy, financial damages. So these are different terms. Most important term is exclusion clause. Clause means terms. Exclusion means to exclude, to exempt. So what are we excluding? We are excluding our liability. Our liability. Well, are we excluding it completely? Well, no. Are we excluding it for the main purpose for which the law was formed? Well, no. We are just excluding it for any subsidiary or side purpose, and we are just limiting our liability. For example, a sign saying parking at your own risk. A sign outside a college saying parking at your own risk. So they are limiting their liability. They are not taking any liability for the vehicles of the students, which is not the main purpose why the student is paying fee and why is the student coming to the campus for. So can we put exclusion clause over there? Yes, we can put exclusion clause over there. However, the court says you have to satisfy two conditions. Condition number one, it should be properly incorporated into the contract. Condition number two, it should be properly interpreted. Two conditions. If you can satisfy these two conditions, then yes, exclusion clause can be used. Condition number 1. Exclusion clause should be properly incorporated in the contract, embedded in the contract. It should be made a part of the contract. Well, if the exclusion clause is written on a signed document, it should just be clear, even if it is in a small font, even if the text size is small, it is okay if it is clear, if it is readable. It is okay if it is readable. Okay? That is the rule for signed documents. That is the condition for signed document. If the exclusion clause is mentioned in the unsigned document during the contract, for example, it is written on a receipt or a ticket, well, you have to mention the exclusion clause on the front of the ticket, and if it is mentioned at the back of the ticket, you have to give any hint like for conditions, see back. Only then it would be incorporated. For condition, see back. If it is a notice, it should be present at front. It should be brought into the attention of the customer before entering into a contract. Before entering into a contract, the notice should be brought into attention. Until and unless it is a case of consistent dealing. If you have been dealing with this company consistently for years, then it is okay even if the notice is given a little late. However, there is another condition as well, that is known as onerous term, one-off term, unusual term. If you're giving exclusion clause and that exclusion clause is really unusual, then you have to make it a point. You cannot use all these rules there. You have to make it a point that you write it in bold letter, in colorful format, in very clear letter, and it is highly explicitly visible to the other party. Why? Because it is an wondrous term, one of unusual term. So these are the rules regarding exclusion clause, incorporation and interpretation. These are the rules regarding incorporation of the exclusion clause. Well, for interpretation, exclusion clause, incorporation, these flowcharts would really help you learn the theory. And interpretation. Well, exclusion clause should be properly interpreted. If there is any ambiguity in the clause, it would go against the party which has relied on exclusion clause or which has put the exclusion clause in the contract. If there is any ambiguity in the exclusion clause, it would go against the party which has relied on the exclusion clause or put the exclusion clause in the contract. So it should be it should be in a format which anybody could read and interpret properly. If this happens, it is going to go against, if there's ambiguity, against the party which is relying on the exclusion clause, and this rule is known as contra profrentum rule. And exclusion clauses are not for main purposes. Well, to limit the effect of exclusion clause, there was an act, UCTA, Unfair Contract Term Act. Well, this act says in certain conditions, exclusion clauses cannot be used. Even if they are properly incorporated, even if they are properly interpreted, they cannot be used. For example, for death or personal injury. For example, for sample size. For example, from right to sell. You cannot say, I'm selling this, but you cannot ask me if I have a right to sell this or no. You cannot use it for the warranty clause. And even if it is not from it is properly incorporated, exclusion clause, it is properly interpreted, it is not from these four categories which are void under UCTA, which says that no, this exclusion clause should not be at its place. Even whenever the court thinks that it is reasonable that this exclusion clause should not be made a part of the contract, court says, well, no, it should not be the part of the contract. And generally this came up as a helping hand for the consumers, because companies would put certain conditions under the exclusion clause which the consumers were unable to understand, unable to interpret, and they had to bear the harsher consequences, the harsher effects. So to protect them from exclusion clause, UCTA came up, Unfair Contract Terms Act. Unfair Contract Terms Act. So remember, no exclusion clause on death or personal injury, on sample, on right to sell, on warranty, and even whenever it is considered reasonable. Let's see what the examiner would ask about this. So what are exclusion clauses? Clauses which purport to exclude liability altogether or to restrict it by limiting damages by imposing other onerous conditions. It should be properly incorporated and interpreted. So there are certain clauses under UCTA which are void. Exclusion of liability for death or personal injury, for consumer use, defects, samples, and for right to sell. And all these things regarding exclusion clauses. Let's see how your examiner basically asks questions on these areas. A vast majority of contracts are simple. Well, we have done this. This is a repetition of a question, sorry. Breach of which would not entitle the innocent party to repudiate the contract. A warranty, a condition, and innominate term. Warranty condition is a major term. Warranty is a minor term. Under the major term, the remedy that you get is the financial damages, and you can even repudiate or terminate the contract. However, for a warranty, you cannot do that. The answer is A. And innominate term is basically the third category. Innominate, I have a little space over here. Innominate, I'm writing it over here. A term which is left at the discretion of the court, that court has to decide either it is a condition or it is a warranty. Court decides on this, that if it is a condition or if it is a warranty. That is innominate term. The types are two, major or minor. The sources are two, express or implied. The answer is A. As you can see, for major, 2 remedies, for minor, just 1 remedy. So the answer is A. Which of the following is a correct rule for valid consideration? Consideration must pass from the promisee. Consideration must be adequate. Past consideration is generally a valid consideration. Executory consideration is generally not valid consideration. Well, D, executed consideration is valid consideration. Past consideration is not valid consideration. D and C could not be the answer. It is A or B. Consideration must be adequate. Adequate means equal in value. No. Consideration should not be adequate. It should be sufficient. It should have some identifiable value. It is not a must that it should be adequate. It should be sufficient. And consideration must pass from the promisee. Well, A is the answer. A. A is the answer. Which of the following statements correctly describes express term? They are regarded as conditions. They are always in writing. They are terms that the parties have specifically agreed. C. C is the answer to the question. Specifically agreed. Well, the principle of privity means, the doctrine of privity of contract means, a contract is not legally binding if it is a private agreement. Only the parties to a contract can enforce it. The terms of a contract are primarily the concern for the parties to it. Any ambiguity in the contract will be interpreted against the party trying to avoid the liability. Well, B is the answer. Only the parties to a contract can enforce it. Which of the following statements concerning privity of contract is correct? Privity of contract means only party to a contract may sue on it. Privity of contract is not subject to regulation of the state. It is. There are no exceptions to the rule. There are. Privity of contract is only enforceable on commercial contract. Well, A is the answer. Only a party to a contract can enforce it or can have other rights. Which of the following is executed consideration? Providing goods in return for payment at the same time. A promise for payment in return for the provision of goods at a later date, that is executory. A promise to pay for good already carried out, that is again executory. A, providing goods in return for payment at the same time, that is executed consideration. Which of the following is not a valid method of acceptance? The offeree's express words, the offeree's conduct, silence. Which of the following is not a valid method? Well, silence is not a valid method. So these are the certain areas that we have looked. Some of them were regarding English legal system. We had a discussion regarding English legal system and certain types of laws, certain different codes of law. We talked about sources of law like delegated legislation, judicial precedent, statutory interpretation, and then we talked about certain things in contract, offer and acceptance, intention, consideration, terms, and exclusion clauses. So all these slides are available for you guys. If you have any questions, you can ask. Students, if you have any questions, you can ask me. Well, these slides should be used along with any study text. You need to have any study text, and you need to have all the knowledge mentioned. You can use any Kaplan or BPP, but you should have all the technical knowledge before you sit in the exam. Okay, students, you can put up your questions if you need to know anything regarding this webinar. Well, the recordings would be available, and you'll get the intimation when the recordings are available. You will be informed when the recordings would be available, and email ID would be shared as well. You can put up your questions later in the day as well. So certain technical areas regarding English legal systems were discussed, the types of laws, certain hierarchy of the courts. I've told you all those things in detail. Okay, next time I'll give you some time to think of the answer. So tomorrow onward, I'll definitely give you some time before I tell you the answer. So it's always a good practice to go to the questions once you basically go through all the major technical areas. You can use this platform as a revision platform. You can use this platform as a practice platform once you're done with all your preparation. And this platform, inshallah, will help you out in your practice and ultimately passing your exam. So request to share the PPP book. It has been forwarded. You'll be answered soon. English law. You should go for English law. Well, that is our recommendation. You can opt any. I hope that answers the question. So these are the type of questions that would be asked in the exam from you, and there'll be options. And as I told you, 25 2 marks questions. When you have to choose between four options, it's a 2 marker question. And generally, when you have 3 options, and you have to choose between 3 options, it's generally an easy knowledge-based 1 marker question. So you have time to ask questions. So any question regarding any area that we have studied today: English legal system, contract law. Okay, I think. Okay, you want me to repeat civil versus common law? Well, there's no distinction between civil versus common law. It is civil versus criminal law. Criminal. Criminal law, and then we have civil law. Criminal law for everybody in a community by an authority. Civil law, not for everybody, it is between the individuals. So in this criminal law, the claimant or the prosecutor is always the state. So you have to write state versus the name of the person who the state thinks is a criminal, or you can write R versus the name of the person. However, in civil law, you have to mention both the name, claimant versus the defendant. Burden of proof is on the prosecutor here, and likewise it is on the claimant over here. Standard of proof, that how much proof is required. Well, for a criminal law, it's a serious offense. So beyond, because it is a serious offense in a criminal law, beyond reasonable doubts, and for civil law, it is on the basis of balance of probability. You just have to prove that there are enough chances, enough things that they're suggesting that the defendant has breached the contract. And what remedies are available? Well, fine over here and fine over here, but imprisonment over here as well. No imprisonment. You cannot offer, you cannot order imprisonment over him. It could be fine or any other equitable remedy. So that is the comparison that you asked for. That is the comparison, civil versus criminal law. Well, the state has to give sure short proofs, and they have to definitely prove this thing that the defendant is guilty of that crime. Defendant is guilty of that crime. When the judge is fully convinced, when the judge is completely fully convinced, only then he's going to announce the penalties. For civil law, whenever the judge is convinced, based on the probabilities, he's going to announce the compensation, as the remedies are not that harsher over here. So these are all about contract law and English legal system. Tomorrow we'll start off with the breach of the contract. Today we have formed the contract. Tomorrow, inshallah, we'll start off from the topic of breach of contract. Well, that is all for today. Thank you so much for joining. Do sign in tomorrow as well. Thank you.